Welcome to my channel, All for Health with Jane. Family, today it was a very sad day for Pastor Mboro. You know, when he thought that after the bail application hearing, he would go home, but instead it was the opposite. You know, you could see him with teary eyes in court as the magistrate pronounced that Pastor Mboro and his bodyguard won't go home, but instead the bail application hearing was postponed to the 21st of October, which is full 2 months from today. Family, it was indeed very sad. I believe even for the members of his church who were in this court, this was very, very sad. We are going to watch the first clip where this case is being explained to the court. Family, let's listen.
Ila hlalosa gore yena o sebetsa mo le hape wa netefatsa gore bana ba dula le mme le ntate wa bona empa mme sa hlokofetse le hape wa hlalosa gore mme le ntate wa bana ba nyala wa hlalosa gore fa mme a fetsa go hlokofala wa mme bana ba ile ba simolola ba lo dula le kgolo wa bona ya tsamayang mme wa bona wa hlalosa o mo se a se boneng ka di-1 tsa August wa hlalosa gore la bona mothosi wa boraro le revival yena a kena a tloka bana sekolong a sena tokello ya motho tlhokomelang bana a nka bana le hape taba ena ketsahalo ena ba ile ba isa maponeseng ba re bolato le hape maponesa a tsamaya a lo sheba bana empa ka bomadimabe a ba bo fumana le mo a dulang teng le hape wa hlalosa ka letsatsi le latelang bana ne ba sa sekolong le hape ha ne ba tswa maponesa ba lo sheba hape ba fumana mothosi wa ntlha e leng Paseka a na le bodyguard ke mo he yena Paseka a ya ka aja hae a tswa ka diphanga tse pedi ke mo he ka mmanimadi maponesa a motsiba ba sebedisa mopaki o mong hape o la hlalosa gore yena se a se bone gore o bone bana ko sekolong le hape ba hlalosa gore yena o joditse gore ba batlisitswe ke mothosi wa boraro ko sekolong le hape wa hlalosa gore pastor o ile a kena ka phanga le hape a tshosetsa batho ba le ba le ko sekolong mopaki o mong yena wa hlalosa gore o bone motho ya motho a tshwere sethunya se seholo le hape ke mo le ka letsatsi le la ketsahalo a se a se bone o la bona mothosi wa bona ha o khotsa revival a re o batla bana ba hae ke mo he le hape mothosi wa ntlha o la sebedisa phanga ene a itshwere go heke ya sekolo gore a kene ka matlo ka mo he engwe ya melato e le shebaneng yona ke a thuba kgotsa o senya thepa ba ne le la bula heke ya sekolo ka phanga le hape ba hlalosa gore a le fetsa go ka bana le la thunya moyeng go netefatsa gore batho ba phatlhagana le gore ba le tsela ya go tswa la tsela pele hape a sebedisa mopaki e leng kgone ya bana wa hlalosa gore yena mme le ntate wa bana re ba le ha ba nyala le hape ba netefatsa gore bana ba nkiwe a sa tsebe kgotsa a sa fana ka tokello ya gore bana ba nkiwe le hape wa hlalosa gore yena ka letsatsi le yana ya la ketsahalo eo ana ile a lo nka bana morao sekolo setso empa o makala sa fumana mothosi wa boraro Bible a kene a sekolo a tsa le ka bula heke ka matla ka dintlha tseo wa hlalosa gore yena bonisa le tshwereng molato ona gore bana ba ba nkiwe ka di-1 tsa August go fitlhela ka jeno a ba tsebe go bana ba kae le hape bana ke batho ba nang meriana ba tlameha ba fumane ba tla kula mmeleng le hape a ba sa fumane ba tla sala morao mabapi a dithuto le hape wa hlalosa gore jaaka le batlosuwa le na le dithunya le na le dikulo tse se tlasa molao tsena tse di bontsha le batho ba sa tshepahaleng le hape ka ba batho ba kotsi mo setšhabeng le hape ba hlalosa gore melato ena le etse le bahlano le maikemisetso a tshwanang le hape ba hlalosa gore moqosuwa wa ntlha o ile a tshwenya sethunya a tlhalatsa gore batho ba tloetsileng o tla kgone ho ba lia mo ketsahalo eo ile ya etsala teng rona baqosuwa le tseba bapaki kaofela re tla ba tshosetsa re tla ba kenya ka kelello fane ka lekolla le hape la tseba gore melato le tshwaretseng lona le ka qosuwa go tsela fumana la molato le ka tlhatlhelwa nako e ngata se hlalosa gore fane go tla ka lekola ka pele le ka balea le ka dintlha tseo le hape wa hlalosa gore bangwe ba setšhaba ba tletse mosito le hape ba tshepisitse go le bolaya ke ka go ba ile ba tupisa kgotsa ba besa kereke ya lona ka dintlha tseo tsotlhe go kopana go tlalisa dumela kopo ya lona ya go lekola ka pele motlhalo wa tsebo.
Thank you. Yes, Mr. Vidakasi, that's the evidence for the respondent, correct?
Bishop, sorry?
That's the evidence for the respondent.
In this session.
Ready for arguments, Mr. Lamini?
Your Worship, I have just requested my colleague to provide me with the statement that has been read, and not to disturb the court, I could not, because he was reading fast, I could not follow properly. And in my advice to the third respondent, I thought that the death accused number 3 of the third applicant, that despite that the issues that were the statement read to the court, I had not seen it before, and up to now I do not have a copy. But I felt that he can draft something to reply to some of these issues. That, Your Worship, I will ask the matter to stand down for my brother here to get me a copy, and at the same time my attorney to commission the affidavit of the third applicant, just replying on.
Family, I'm sure you will agree with me when I say not only South Africa, instead the whole world witnessed as Pastor Mboro had pangas and a rifle going into that school, you know, having them in front of the primary school kids. But today in court, when the prosecutor informs the court that Pastor Mboro had them, look at how shocked Pastor Mboro is. He is so shocked, family. It's like they are lying. And this will be leading to us as South Africans, especially those who are following Mboro, those who are in his church. People will be saying they are lying. It's like those who are saying, in fact, there is nothing wrong that Pastor Mboro did. Pastor Mboro was protecting his own. Not in this country. You can't just walk around with guns. It doesn't matter whether that gun is licensed. You are not allowed to just walk around with it, you know, scaring people with it. No, you are not allowed. Not in this country. Now, people are saying there is nothing wrong when Pastor Mboro had guns, a rifle and pangas with him at a school premises, a primary school premise for that matter. Family, in the next clip, let's watch as the magistrate is now summarizing the case in order to give a ruling in terms of the bail application. By the way, we are still on the level of bail application. So let's listen as magistrate is denying bail to Pastor Mboro and his bodyguard, but instead at least giving Pastor Mboro's son a release on bail, and he will have to be present in the next date of the court, which is the 21st of October 2024. Family, let's watch.
Fully canvass the provisions that are of importance in determining whether a candidate is suitable to be admitted to bail under Schedule 5 offense. Applicant number 2 fails to address the issue of him being a good bodyguard and whether he is registered by the applicable authorities to become one. He does not dispute that he holds no firearm license, and he does not dispute that he was on the scene of the incident. All he gives to the court is that he intends to plead not guilty. The investigating officer also submits that applicant number 2 was brandishing a firearm which was described by the witnesses as a rifle. The court cannot ignore this point. I now turn to applicant number 3. Now, inasmuch as applicant number 3 gave a sloppy affidavit which does not tell this court much, case in point, he says he is a widower but does not provide proof to this effect. The investigating officer's affidavit comes to his aid and assists applicant number 3. The investigating officer gives a background of why the said incident transpired. The investigating officer also does not mention much apart from him opposing bail against applicant number 3 in that his address is negative. I have concluded above that the court takes no issue with the addresses that they have been verified. Now, Advocate Lamene, counsel for applicant number 3, correctly points out that applicant number 3 does have parental rights and responsibilities as protected in Section 21 of the Children's Act. There is no court order before this court that states otherwise. The 2 minor children have only one parent, and that is applicant number 3. To deny the applicant number 3's right to take care of his minor children will be an injustice to the end. This court will not go down that route. Now, the investigating officer provides a picture to the court of what exactly happened on the day of the incident. What is also worth noting is that the investigating officer suggests that it would be beneficial for the accused to be kept in custody as a measure to protect the applicants before this court. The affidavit is clear that there is an outcry and displeasure of the accused's conduct. To have a prominent pastor commit such a heinous act in the presence of minors, which he ought to have protected as he is their grandfather, has left the community angered. So much so, as the investigating officer stated, in that the applicant number 1's church has been burned to ashes. This is indicative of the anger of the community. Perhaps they could as well be paying for his blood. The affidavit of the investigating officer also shows that there are too many witnesses who were subjected to this ordeal, and what could also not lose sight of the fact that this incident occurred in a public school where minor children are enrolled at such school. The conduct of the applicant may as well have left the witnesses and learners traumatized. Now, Section 28, subsection 2 of the Constitution tells us that the fundamental point that the best interests of the child are of paramount importance, and as such, it is the duty of this court to protect children and ensure that they are protected in the environment where they receive education. This is not only in respect of the 2 minor children affected by this incident, but by the learners of the said school where this incident transpired. To be brandishing dangerous weapons and firearms in an environment and institute of learning, the court shuns the behavior of such. Now, in the case of S. vs. Shabalala, it was stated that the court must assess the appellant's future conduct in the light of existing or historical facts and circumstances. I cite this case in support of the factors listed in Section 60, subsection 4A to E of the Criminal Procedure Act. The court then must balance the right of the accused and those affected by the incident. Did the applicant discharge the onus placed on them? Do they satisfy this court with the evidence that they have placed before this court with the affidavit that they are suitable candidates for bail. Now, the only thing that this court must do is just to make sure that it's satisfied that all three applicants before this court, they can attend their bail, their case before this court. This is not the duty of this court to determine the guilt of the accused, as I've said. That's for the trial court to do. Now, it is quite unfortunate that the affidavits presented by the applicants before this court were not satisfactory, and simply they were just not giving of anything. The onus rests on them to demonstrate that they've adduced evidence that which are in the interest of justice to permit their release. The court has considered all angles and dissected the affidavits, and simply there is no indication that the said onus was discharged. This court is a creature of statute, and it does not operate on emotions and or influence. It is not a reactionary court, but simply deals with the facts presented before it. It is a creature of statutes and does not have inherent jurisdiction as that of the higher courts. So it simply can only do what is permitted to do within its own legislative framework. If the applicant fails to discharge the onus placed on them, then it is therefore clear then what should follow as a result thereof. The applicants did not have an obstacle of discharging the higher burden found in Schedule 6 bail applications. They simply needed to demonstrate to this court that the interest of justice permits their release, as opposed to the higher test found under Schedule 6 bail application. Their affidavits do not dispute that they are linked to the offenses preferred by the state. There is a strong case against them, and frankly, they did not put up a fight in ensuring that the evidence submitted by them hold enough water to discharge their owners. Now, I have expressed above that the investigating officer comes to the aid of applicant number 3. It is clear that the investigating officer has no reason why he is opposing the release of applicant number 3, and in the circumstances, the court must do what is fair and just. Applicant number 1, 2, and 3, please stand. Now, the court ultimately looks at what is presented before it, and it provides a valid judgment from the said evidence. This court is persuaded that this case consists of so many probative factors which tips the scale in the respondent's favor. Now, in considering all the evidence before this court, the evaluation of the factors listed in Section 60, subsection 4 and 5 to 9 of the Criminal Procedure Act, applicant 1 and 2 have not discharged the onus that rests on them and have not adduced any evidence which has satisfied this court that it is in the interest of justice that they be admitted to bail. Applicant number 3, there is no basis that he should be detained until the finalization of this matter, and therefore the court shall grant his release from custody. So then the order is as follows. Applicant number 3, you are released on warning with the following conditions. You are to have no direct or indirect contact with the witnesses of this matter, save for the maternal grandmother and aunt under the guidance and assistance of the Children's Court. You are prohibited from entering the said school premises where this incident occurred up until the finalization of this matter. The court is aware that this condition, it will impede you exercising your parental rights and responsibilities, but this is only until the finalization of the matter, alternatively the outcome of the Children's Court matter. You are therefore warned to appear at the Knox Court date, and failure to do so, you may have your release on warning cancelled. And therefore, applicant number 1 and 2, your application for bail is hereby denied. Sivilakazi date? Date? I don't know. Then the date with the defense then. It will be for investigations, correct? The date, Advocate Dlamini? I don't know.
I understand, Your Worship. However, we're going to be in the same position because if we get a shorter remand, we're going to ask for postponement again for further investigations in any event.
Your Worship, 2 months. Accused number 1 and 2 in prison. That's completely a situation where they are denied.
So the state is saying that they still need to investigate. And I'm sure with ballistic report, we know the situation at our criminal laboratories, that there's a backlog there. So surely that ballistic report is going to take quite some time. Hopefully it will be sped up.
Can I consult? Your Worship, we will accept the state proposal, but we need a date, Your Worship.
Yes, you must provide me the date. Look at your diary and let me know.
No. You said 2 months. Well, you must give us a date.
Okay, indulgence. The 21st of October.
What day of the week is it?
Monday.
Is it suitable, Mr. Dlamini?
It's suitable, Your Worship.
Judgment will then appear in District Court number 2. That's the reception court. On the 21st day of October for investigations. Accused number 1 and 2. Since your bail has been denied, you shall remain in custody. Accused number 3, you are released on warning with the condition that was set before this court. You are warned for 8:30 District Court number 2. You don't come to court, a warrant of arrest will be authorized against you. 21 October, EC2, 8:30.
Family, the ruling has been pronounced. Pastor Mboro and the bodyguard will remain in prison until on the 21st of October 2024 for their bail application. His son will go home and come back on the 21st of October 2024 for the court hearing. Family, Pastor Mboro, we see him praying as the magistrate is reading out the ruling. We see him praying, asking God, you know, to perform miracles on his behalf. Indeed, God hears our prayers at the right time. God will respond. God will answer the prayers. Maybe it is the right thing for him to be kept in prison now that the community outside there is still very angry about what he did. So maybe it's better if he is kept in prison until, you know, things calms down in the location or in the community. Family, thank you very much for watching this video to the end, and thank you so much for liking this video. Subscribe for my channel if you haven't done so yet. I love you, family. Thank you. Bye.